Subscribe to our YouTube channel and click the bell icon.
As most of you know, the judiciary responded to COVID by enabling hearing of urgent matters and mainly through video conferencing capabilities. And yesterday, a lot of interesting questions were raised over the arbitrariness over what is declared as an urgent matter, what is not, what is the jurisprudence that exists around it, and also how inclusive these processes are. And what we felt is this moment and the court's response clearly deserves a much, much deeper exploration. Because by conservative estimates, we expect that the lockdown and the impact of the pandemic is going to last at least another 6 months, if not longer. And as providers of essential services, which it has been declared that justice is, the courts will, at least like I believe, resume full caseload in the near future, if not immediately. I find it very, very interesting that hospitals and other essential services are not resorting to only functioning on urgent only cases, right? They're not turning down patients with chronic lifestyle or even dental problems. I could take my son for his regular vaccination shots that he needed. So why are we all not holding the judiciary to the same bar? And why is the judiciary not holding itself to the same bar? And why we as society are not holding it to the same bar is a question that I have. But I think what we felt is rather than explore what we should and should not be declared as an urgent matter, what we thought would be really, really interesting for this call is for us to ask ourselves, how can the courts resume full capacity, if not develop extra capacity in a time like this when actually justice miscarriage is higher? Right now, we're going to be seeing, due to orders passed by the executive and and other circumstances, people are going to face higher justice issues, and it feels like the right time for the judiciary to step up to being able to function at a higher capacity. And none of that can happen without a fundamentally big shift in how courts function. They have to function from moving from being primarily like places to being a service, right? As Suskin talks about it. And technology can only be a key enabler of that. Mindsets, capacities also have to critically evolve with it. And what, of course, we all know is the eCourts mission and the work over the last couple of decades have laid some ground for it. A lot of things, like was even mentioned in the call yesterday, video conferencing is not fundamentally new. And orders also passed by the Supreme Court over the last 10 days indicate a shift towards greater digitization and the use of technology to improve the administrative aspects of the judiciary. Here, we're not talking for the purposes of this call, we want to make sure we're restricting it to the administrative aspects and not the substantive dimensions. But what is, I think, a critical invitation to all the panelists today, just to keep in mind, is that we try not responding, or at least like we bring in our ideas and thinking not just from a short-term emergency measures to ensure that we are to not merely be reactionary and looking at short-term emergency measure. We believe if we think through this moment well enough, yes, and still respond decisively and well, it can lay the ground for a radically better and evolved system. So can we ask ourselves not only how to immediately overcome the threat that and risks that are there today, but what kind of a world do we all want to inhabit after the storm passes, right? And what our reaction should ideally be grounded in that, not just in responding to the immediate threats. So can we explore together beyond video conferencing, online and hearings? Is this an opportunity to put in place mechanisms that can make online payments for courts, improve judge support mechanisms in terms of templates, workflow, document management, transcription, notifications for hearing, written submissions potentially being the primary mode for case representation, amongst other things. And there is global evidence and reason to believe that if this is done right, and that's the operative part, it can help reduce pendency potentially, the time of courts, lawyers, costs for litigants, and maybe even reduce bias. And I would invite all the panelists to enter this conversation and share their ideas, keeping in mind a few critical principles. First, how do we ensure that we do this in a way that's inclusive? For example, like Zoom is not available to the poorest, but what technologies are and how do we design for that possibility? How do we do this in a way that retains issues of trust and transparency? So how do we keep a lot of the core values that were so central to the public room and space equally in a digitized world? How do we enable choice, dignity, and agency in this process? All of this might require new institutions, technologies, capacities, mindsets, and even maybe changes in legal procedures to be looked at. And we felt like this moment, more than any other so far, maybe also a requirement for the courts to work differently, to work with civil society, technologies, technologists, universities, and the legal community to respond using the collective intelligence that's out there. So with this broad framing and context, I invite all the panelists to share their opening remarks. A quick note to all the participants, we will keep the last 20 minutes of the call for your ideas, suggestions, and questions. So please do share them in the chat room or on the comments on YouTube. I'd like to start with Justice Sri Krishna and then follow on with everybody else. But Justice Sri Krishna, if you can open up, and the same question will hold to all the panelists. Can you start by maybe sharing one key observation that you have about the reality we find ourselves in, about the courts? What are you witnessing that may be really unique? What are the two biggest risks you see, and three big opportunities for action? And the focus is a lot on as much on point 3 as much as point 1 and 2, because we'd love this call to give direction to all of us interested in playing a role to see what we can do. So we'd love as concrete as you can be towards the opportunities for action. So over to you, Justice Sri Krishna.
Although, we've had experiments, even when I was there in the court and much before that also for some time, of how to digitalize the whole process of judicial administration. Apart from being a photo operation, it did not succeed much. Now, all that you need for a successful litigation process is filing of documents, which can be done electronically, which can be done digitally. There is no difficulty on that. Then probably you need a face-to-face interaction. Now, if it can be done electronically like this, I see no difficulty at all. It can be done very easily. The only problem is I'm not sure if the courts and particularly the judges how comfortable would they be in using hardware and software that is not developed by a government machinery. This is probably more a matter of mindset than anything else. And now is, I mean, as the saying goes, when the house is on fire, you start digging a well, you're not going to douse the fire in any case. So the question is, whatever is available to you, why don't you make use of it for tiding over the emergency, and then in the meanwhile you develop your own software, your own hardware to your own specific standards, which will meet with government approval. So there should be no difficulty at all. Now that's why, for example, we are having this kind of an open-ended conversation. Now, why should this be limited to the situation of the lockdown? Why can't it be a permanent feature? Any court, whether it's a district court or whether it's the High Court or the Supreme Court, can carry on with this without any difficulty, as long as 2-3 things are necessary. There should be some kind of security of the voice transmission, security of the image transmission. If it is guaranteed, then there is no difficulty at all. Now, you have Honorable Judge Justice Lokur there. I can address him from here and he can either agree with me and grant me a bail, or he may say utter nonsense, Mr. Judge, sit down, there is nothing in your arguments. He can do that as well. He has done it in the court. He can do it over the video. What is so difficult about it? Would you agree with me, my Lord Justice Lokur? I mean, it's a matter of mindset, according to me. It's just a question of getting used to it. The human tendency is to oppose change, irrespective of whether the change is for good or bad. As soon as somebody says, make a change, you'll step back and say, no, I'm quite happy with what I prefer to walk in my old shoes rather buy a new pair of shoes. This is the attitude. Otherwise, I don't see any difficulty at all. One question might, however, arise. If all the work has to be transmitted digitally and carried on electronically, particularly for image transmission, there may be a question of bandwidth. Now, that is something that the government has to solve. It is not something that the Supreme Court can solve for us unless they get into a judicial mode and issue a direction to the government to release so much bandwidth. Because lack of bandwidth will make the equivalent of call dropping, image dropping, or image freezing on the screen. That will probably be a big technical issue that will have to be solved by somebody in this country. And I'm not sure what other video conferencing softwares are available. Can somebody enlighten me on that? Because I've tried out the normal thing that I use for talking to my family members is your FaceTime. You have Skype. I've tried Skype. Then you have now Google Duel, which are for individual face-to-face interaction. Now, Zoom is something that I've tried, which you're also using right now. Which other software is available? I'm not quite sure of that. So somebody will have to look into it.
That's a good question, and I'm sure people both in the community who are listening in and who are on this panel will have interesting responses to it. It was interesting to hear. Essentially, you're talking about this needing to. What I'm hearing you as the opportunity is the opportunity to move beyond, say, working only with the NIC on stuff like this, working with available technologies, tackling the mindset, addressing for issues like broadband and security, but and exploring like what technologies are out there. Can I take it forward to CSV, sir, from here? So you have to unmute yourself.
Sorry. I thought.
Sorry, it's gone back to mute. Yeah.
Am I audible now?
Yes, you are.
Okay. Good morning, everybody. Now, you know, the world is thinking of slowing down and reflecting and saying that, look, this is a change which has been brought about thanks to COVID-19. And we are thinking in judiciary, we need to speed up the whole thing, speed up the reform. This is a contrast where life otherwise is taking a slow turn. That's the first point that I want to make. Second, look at the statistics involved. We have about 20,000 judges. We have about 4 crore cases and about 15 to 20 lakh lawyers. We don't know how many. Bar Council doesn't know how many lawyers are there. This is the kind of numbers with which we are dealing. Thirdly, on the infrastructure front, I was going through the 500-page report of Justice Lokur of last year. And I find that substantial progress has been made in regard to infrastructure, the software, the back office. But in regard to actual online court functioning, the only experimental stage that we have gone is in respect of traffic offences. We have not actually seen the court functioning. It is only now, after the COVID-19, we have the some of the courts experimenting with hearing through video conferencing. So this is the substantial jump that we have to think of. Now, on the mindset, from what I have seen in regard to the kind of training that has been given to the judges, it appears as if at least 80% of the judges will be prepared to experiment or on an ongoing basis have this system. Whereas I'm afraid, so far as lawyers are concerned, it will be 80 against 20% supportive of this online video conferencing. This is going to be a major thing. And let me tell you another thing. Places where actually such online courts have taken place, there has been a substantial replacement because the forms are reduced, shortened, and therefore self-representation in a number of matters, family law matters, motor vehicles offences, negotiable instruments act offences, etc. will come. So the lawyers could have the apprehension that if self-representation is going to come, they are going to be out of the job, out of profession. This is a real threat that they are having. But in any case, lawyers are the most resistant to change, and I will expect that, but for about 15-20% who will be receptive to change, 80% will be very, very hostile to any such experimentation.
See.
Now, in regard to this online course, I think some major changes will be needed. One, apart from mindset, we have to be very conscious of time. And time management is going to be extremely important. See, when we are ready to embrace technology, what happened? When we embrace technology, I have seen a half-page judgment, handwritten judgment, 1.5-page plaint, 2-page or 3 pages of writ petition, which used to be there earlier. Now, thanks to the cut and paste that is going on, we have 100-page judgment, 50-page plaint, 75-page writ petition, etc. Therefore, when we embrace technology, this is going to be a major issue. People should be able to utilize it for the purpose of cutting down paperwork, cutting down time, and then agree to time-bound resolution of disputes, 10, 15 minutes, 20 minutes maximum hearing, not beyond that, except in exceptional matters. Now, in regard to transparency, I think one of the important things is the institutional integrity is dependent on public gaze and transparency. Now, in most of the matters, maybe 95%, 98% of the matters, it is going to be only as between parties who need to have access to these video conferencing facilities. But in regard to the matters which impact public interest, maybe about 2 to 3% of the cases, I think the larger public will be interested, and therefore, I think live viewing should be possible for the larger amount of public, so that the institutional integrity, which is the cornerstone of the public confidence in the institution, is kept up. I think, therefore, that is going to be another major important thing that we have to consider.
CS, can I interrupt you for 1 second?
Sure, sir.
Yeah.
What happens in a normal hearing? I'm sitting in a court. I allow people to come into the gallery to the capacity of the court. Beyond that, I will say, sorry, I will not allow, because it will crowd me and make it inconvenient for people to argue. Now, why can't this be done? So, as far as your video hearing is concerned,
therefore, in
you can say, I will allow.
Most of the matters, I think it should be possible to restrict the viewing only to the parties, the advocates concerned, parties concerned, and maybe in the Bar Association, you put up a public display panel where it should be possible for anybody to view. But in matters where public interest is involved, civil liberties are involved, fundamental rights are involved, I think the larger public will have an interest in viewing. And that's what I think that we should keep in mind. Now, out of about 4 crore cases, I think if we take up about, take all these family law disputes, Section 138 negotiable instrument cases, then road traffic accident cases, etc. These will take up about 1 crore of cases. These are all matters which should be compulsorily sorted out through mediation, through video conferencing, without the parties having to be present at one place. And that is a substantial bulk of the cases that we have today. I think we also need to create a fully skilled army of judges. I think now the objection which has been raised by the High Court and the state governments in regard to an all India cadre of judges, this is the best time to deal with it, and we should be able to evolve, get through that, and then have a substantially large number who will be able to deal with it. I think the one number of pages, pleadings, submissions should be severely curtailed, time limit should be imposed, and with this, if we are able to take off, even if we are able to achieve about 25 to 30% of the cases being disposed of through online courts, I think we would have seen a seismic change and then the inflection point, and we should be able to take off. I think this is broadly the scope of what I wanted to say in the beginning. Thank you.
Thank you so much. There were several interesting points that you brought out. Everything from where assistance might come from, potential, because change has implications. And so you spoke about its effect on lawyers, issues of time, mindset, and transparency. So thank you for bringing all of those up. I'd like to now move to Jamshed. Would you be able to share like what you're observing and seeing as the opportunity for action?
Sure. The benefit that I have is basically I've also been able to, as an Indian lawyer, practice law outside of India, and Therefore, most of these concerns that the Honorable Judge and Mr. Vaidyanathan have raised have already been gone through in several jurisdictions, including countries like Nigeria in Africa. So one judgment of our Supreme Court, which is that Swapnil Tripathi and others, wherein the Supreme Court had the benefit of hearing this for almost a year, and it came out on the same day as the Aadhaar judgment, where they've now said the principles of live streaming and legal transcription and other modes has been confirmed. I think that's very important, and we need to, and that has really helped the Supreme Court to take these very quick decisions on video conferencing. We must not forget that there have been orders of, I mean, I know for a fact for the Bombay High Court not so long ago, which said that, video conferencing was terrible, and they had castigated the petitioners. But under 141, 142, Supreme Court has said nothing doing, and this is a new uh, time. You also, this is again, I think very rightly, as we know, this is not something that has happened overnight. The Supreme Court and Justice Lokur is here. They have done a lot of background work. People have attended. For example, Denmark has done tremendous amount of work on online, courts and things like that. I had occasion to appear in a particular matter in Canada, where, for example, obtaining bail was very easy. The person didn't have to come and present himself or bring his the surety. He could go to a justice of peace who then rang up the judge again through video conferencing, and that was done. So it was much easier. As lawyers, I think it's a similar situation that when we had the landline and we went to the mobile phone, there was a difference. So how I think it needs to start from our next generation as well. I mean, law schools need to bring this into as a part of their drafting, pleading, and conveyancing as a subject. We are global today. Let's not forget about that. The transactional lawyers have been using these methods for a long time. It's only the law courts and litigation lawyers that we think that this is something different. So we need to adjust. Yes, time frames are important. All these things can be done. I'll give you a shocking fact. When we were arguing at the Supreme Court, we tried to find out when was transcription actually used. It was used at that time, the Supreme Court of Bombay in 1908 in Tilak's judgment. What happened between then and 110 years later? Why was transcription given, shown the sort of the back door? I think, and the whole objective is open justice. Also, the other great example is the International Court of Justice. What does it really do? It basically ensures that every day's proceedings, the transcript is available. We saw that in Kulbhushan Jadhav's case within 2 hours, and the recorded version is available the very next day. So, at any given point of time, you can go back and refer. This is great, not only from a law student's perspective, from the perspective of the media, who very often, unfortunately, cannot hear what the judge says and therefore does not report accurately. The court also has another very interesting system, that is the Supreme Court of the UK and ICJ. They come out with a press release, and the date and the time for the particular hearing is fixed: morning session, afternoon session, etc. On the issue of what can the government do? Yes, the bandwidth definitely needs it can, that is very easily possible now. There's no difficulty. Technology, I think we have the best brains in the world. There's no difficulty at all. I mean, Bangalore, from where a few of you all are is an amazing place where all this, it just needs to be brought in.
Yeah.
Just as you had stenographers, for example, in those days, who used to write everything down. At least they were told to write. Uh, I mean, transcription meant that they had to write down everything. The
Yeah.
legislature, for example, used this as a methodology, and they used to change them every 15 minutes. And I think all these things can actually work all in tandem. And I think we are probably going to see this as a permanent feature. I don't see this as an ad hoc system. And I think we can probably, have a hybrid of, matters happening in court and, through the video system. But I really need to congratulate our the members of the bar, the judiciary, past and present, and most often it's the citizens who've actually helped bring us to this position. The virus only has accelerated it. Thank you.
Thank you for that, Jamshed. I love the framing of the ambition being about open justice and and bringing in global experience that show that this is possible. And I think a common point that both you and CSV sir have talked about is, this is really an acceleration process, if we can learn from it. And equally interesting, a point that you brought about is like, this is all equally a moment to think about the next generation and law students. So we'll come back to some of these points later, but I'd love to hear from Sajan next.
Thank you, Sophia. I think, I come from a slightly different perspective. That's because I possibly think I'm the last of the generation which started with manual typewriters, one side, manifold and carbon paper, and then moved on to a technology-enabled ecosystem where law is being practiced today. One. Two, I will also give a perspective more on technology and less on the administration of justice, because we have people like Justice Lokur in this panel, for whom I have the greatest of admiration. I think the contribution that he has made towards ensuring that technology is interwoven into justice dispensation is commendable. And I don't think, given the size of our judiciary, there is any other jurisdiction which has done as much. So I'm sure he will bring to bear his experience and leadership on to what we are discussing. But to my mind, and more so as a technology lawyer, I may be completely wrong, but permit me to place this for everybody's consideration. But to my mind, these are questions which should not even arise today. For a minute, permit me to juxtapose this to, let's say, one odd project called the Bhumi project, which Karnataka took up to digitize land records in Karnataka. 2 lakh square kilometers of land records, 6.5 crore people, and fragmentation of land in terms of cents and cents of land being available. The entire documentation pertaining to land records were digitized by one small state government in the country without fanfare, and which is working perfectly well. And the last year, the downtime for that project, not the uptime, the downtime for that project was less than 0.2% of the entire year. So here we have a Bhumi digitized project where anybody in any part of the state can pull out a land record belonging to anybody, figure out what's happening. And the next level of integration is that you don't even have to go to the sub-registrar's office to register a land record, a conveyance, a gift, or whatever it is in terms of an encumbrance, that even the registration could happen online through digital signatures and electronic commerce being connected in terms of video conference, etc., etc. Now, juxtapose that to our courts. We as litigators find a serious problem. Now, what is the problem? Much has been done in terms of digitization of court records. Yes, much has been done in terms of, at one point of time, every bench in the Supreme Court had these huge panels for digital courts, etc., etc. Now, what was the problem? The problem is that when a Sajan Povaya stands up to argue a matter, I have my case file digitized on my iPad. The court has the same file digitized on its platform. But the one problem is we don't have a common protocol. And therefore, my files are not transferable vis-a-vis the court's record. Court's records are not transferable vis-a-vis my iPad, because we operate on different protocols. So when we talk of digitization of court records, the first thing that we should have is a uniform protocol for digitizing records and maintaining them in a particular file format. We have a unified judiciary. Why shouldn't every court in the country have a common protocol in which records are digitized? Why should it be printed in my, once I have it electronically generated, my petition, once I put it in PDF, I have my digital signature to append. Why should I print it and file it? Forget the Supreme Court. Let's not talk of the Supreme Court. Let's talk of the district court in Madikeri. Why should I print it? Why can't I give it in a file format which the court will accept and which my system will accept? Number one. Number two, when we talk of using technology, this cannot be an answer in terms of saying, oh, we have a malady, we have a pandemic, therefore let us now bring technology, as if a pandemic is an initiator of change. Let's always be clear. Change is never a function of inevitability. Change is always a function of regular process, and particularly in technology. Change in technology and innovation in technology happens only when you follow a particular protocol, and all efforts are on the common protocol. Third, why is that when it comes to arguments in court, you should say that, okay, now because people cannot get into court, there is social distancing, let us use some video conferencing technology. I ask myself why. We are not in 2007, 2008, we are in 2020. If a land record system can be digitized 100%, I ask my question as to why is the court record not digitized 100%? No, Justice Lokur worked enormously in terms of building a national grid in terms of the judicial grid. But when it comes to digitization, some courts have it, some courts don't have it. Yes, new filings are digitized, old filings are not digitized. Lastly, I don't think it's a dearth of technology. We have technology enough and more, as Justice Sri Krishna pointed out, enough and more options when it comes to video conferencing facility, when it comes to availability of technology in the least of bandwidth for purposes of physical arguments, etc. What is the one concern that the court can have? The only concern a court can have is on the security protocol. Whether a particular platform developed by a third party is secure enough for the courts. Again, I put this question to myself. If it is secure enough, let us say for an intelligence agency, if it is secure enough, let us say for Pentagon, why is this not secure to our courts? By definition, our courts are public places. By definition, the security protocol should not really trouble our minds. It's a mindset issue that we don't want to use a third-party software. It's a mindset issue that we want NIC to reinvent the wheel when there are, wheels and wheel-less vehicles which are available. We go back to NIC and say, NIC, you develop a platform. So my view is, and simply as a technology lawyer, out of the available technology that we have, which is third-party technology, so long as a solid licensing mechanism can be worked out, so long as we have a simple uniform protocol that is developed, even the state need not invest in terms of infrastructure, because if the Supreme Court today identifies a common protocol in consultation with experts, the court side of the development in terms of infrastructure, the courts will do. But the infrastructure at the lawyer's end, the lawyers will do. Every law firm will invest into that technology and make sure that we have a platform amenable which will interoperate with the courts. Every senior counsel chamber will do it. Every junior counsel chamber will do it, because technology is not that expensive. The minute you bring an ecosystem onto a common platform, then these questions will vanish. Not just during the pandemic, every hearing on a regular court, instead of having 150 matters listed before a court, you can still list 150 matters, and people can have a choice to say item number so-and-so, so-and-so, so-and-so will be by video conference.
Yeah.
Whereas item number XYZ will be by regular hearing. You decongest courts, you have social distancing, you have cost issue. Why should somebody from Kerala fly every time? A lawyer should fly into the Supreme Court for every hearing, sometimes for a hearing which lasts 35 seconds. Therefore, I think it is a mindset issue, not so much in terms of what we don't have, but a mindset issue in terms of our fears to embrace technology. I will stop at that and, of course, leave the other comments for others.
Thank you. Thank you so much, Sajjan. Some very, very, very interesting points there. The mindset theme is cut through, I think, across the conversations. But for equally bringing this, bringing what the architecture needs to be built on is going to be around like common protocols and uniform protocols, and while addressing security and like other issues. So really, really valuable additions to how we can approach this. Gopal, over to you.
Yeah. Hi, Supriya. Thanks for having me on this panel. And first, may I just commend you on that excellent introduction that you gave us, the nearly 10-minute introduction. You are one more of those individuals that I've strongly believed should have come to the courts and helped us litigate, but you have very smartly stayed out of it. But I'll just get to the meat of the points. I think almost everybody else has covered most of the other issues. There are 3 or 4 points I wanted to highlight. One is my own personal experience. 10 days ago, I appeared before the Supreme Court for 2 separate hearings that they held through video conferencing. And I saw firsthand the shortcomings of the systems that they're using. They're using something called video, VIDYO, which even abroad people had used many years ago and have let slide. Apparently, the Supreme Court of India was told by the ministry that we have about 5,000 licenses lying around. So why don't you use these? Which is why they used it. It was really mind-numbing. There were 2 separate hearings, and I faced the same problems in both. We had several systems on. What they do at the moment is that they send a link to the advocate on record in the case. Now, either he can use it or the counsel that he's instructing can use it, not both of them. As a result of which, the solicitor, who is the only person who has the authority before the highest court in the land, is very often not even on that video conferencing call. It cannot be shared with clients. It cannot be shared with any other person. A separate link is sent to the counsel for the other side, and he also similarly can give it or share it, etc., etc. So as a result of which, normally when you would find a situation where instructions would go from the solicitor to the person who's arguing, the counsel, that doesn't happen, and that requires entirely separate technology on its own. What is even worse is to see that the judges were sitting together in one judge's house. The idea during the pandemic was that nobody would be stepping out of their homes, and the judges had to do it because of these technological issues. Now, in the UK, for example, they've got a clear protocol in place. They're using Skype for Business for the purposes of the Chancery Court hearings. The hearings are going extremely smoothly. One single link is sent out to the judges, to the lawyers on both sides, who can share that one single link with as many other people as they want, including the client. So you can have 50 people with, as you have done, muting their mics. So only the lawyers who are arguing can get ahead. So the Indian system, at least the one that's being followed in the Supreme Court, I know that the Delhi High Court is doing something different. Fortunately, there the judges are sitting separately in their own homes and doing this. But we don't have, as Sajjan was pointing out, a common platform at all, even for just video conferencing. So for me, that's a concern. That's what we're using now, and it's pathetic. It cannot be used. There's no question about that being replicated or used on a larger scale. Hearings would normally take we had about only 10 or 11 cases listed that day before a court. It should have been done in about 45 minutes to an hour. It took 3.5 hours because the link had to be sent repeatedly because many links broke halfway through the arguments, things fell apart. So that's the first point. The second point is that when we're going ahead, I think we must understand, like Sajjan said, we should have had this done a long time ago. If the Bhumi project in Karnataka, if a small company in California can map the entire world, side streets and corner shops with Google Earth and Google Maps, surely a court having a tech system in place shouldn't be such a huge mountain to climb. But there are 4 aspects of this. We can't, I think, in a very narrow manner, just look at video conferencing or just look at filings. We have to understand that the foundational basis that you're going to set in place, which includes bandwidth, which includes all tech support, which includes whatever licensing or getting a tech company to support, should include live streaming, because that is an inevitability. The courts have already said that it will be there, and transcriptions, which are being used in international arbitrations, which, like I think one of the panelists said, has just been given a go-by for many years. It must include the recording and the storing of hearings. The Supreme Court and the High Courts in the country are courts of record. It's necessary for us to have a record of what's happening. Today, we have conflated a record of what has taken place, a record of proceedings, as it were, with the orders which the court dictates. These are 2 very different things. Yeah. The order is the direction of the court. The record of proceedings is what took place in court, what one side said, what the other side said. My experience in court, modest as it is to note that on the second occasion, a lawyer comes and says, I never said that. Now, if you had transcripts, you would easily show that you can't just say that and wriggle out. And that's why clients are raging when they say, look, that lawyer last time said this, and we have to shrug our shoulders and say, sorry, we don't have a record of it. You need to have a record of it. And those records have to be publicly available. The third thing is the filings. Now, the US courts have all filings categorized and serialized and placed, and even the public can access it unless it's exempted for particular purposes. And the fourth is now video conferencing. Now, the platform should be able to take care of all of this, right? And for me, this would include a point that you made at the outset about true access to justice being available to many. Tying up with Mr. Vaidyanathan's point, that the first point of resistance that most people are going to meet with going towards tech is from lawyers themselves. Many lawyers engage us, for example, in the Supreme Court, because the lawyers in the local high courts can't travel. Now, people like us will obviously face a little bit of a cut, because if the lawyer from the local court can do it directly, why engage us, right? So I can imagine that kind of resistance coming in. But equally, Nick Robinson had written about this in the Hindu series many years ago, talking about how, I'm talking from the Supreme Court perspective, how because we are geographically and territorially thrown so far apart across the country, nearly 10% of the cases filed in the Supreme Court come from 2 miles away from the Delhi High Court. But 2.5% come from the state of Tamil Nadu, right? Which is clearly disproportionate. So also about the tech will help people who are differently able, disabled, etc., get a better access than what they are getting at the moment. Over all my years, I've seen one gentleman who's a senior advocate now, Mr. Rungta, who's unable to see, but he comes with braille pleadings and makes arguments. But if you do use tech, there's a great advantage for people like those. So I think tech has those advantages, and we must quickly embrace that. Two other small points is, one, the big problem, at least because it's working from the Supreme Court downwards, the way I see it. We have had previous judges chair the tech committees. Right now is Justice Chandrachud, who had spoken to the judges in the various high courts a few days ago. I believe there should be continuity. We all know the yeoman effort that Justice Lokur has made over the years in his experience both in Delhi and elsewhere, and in the Supreme Court, leading the tech efforts. But I'm not sure, I'm unaware of this, so I'm just saying this. We've noticed this tendency in courts where once a judge retires, right, his wealth of experience needs to be drawn on.
Is it only me, or have we lost Gopal?
And I think it's necessary for that inclusion to take place. So we have Justice Chandrachud heading it. He's going to be Chief Justice in a few years' time. I'm hoping that he is drawing on Justice Lokur's wealth of experience, as well as the wealth of experience of other people involved in taking this forward. I do know that when Justice Lokur was around, we had interacted with the National Knowledge Commission, and there was a lot of work that they had done together. I'm not sure if that's being used now. At least on present evidence and on my own hearings, I can see that it's not being used. And finally, the judges' mindsets is a big obstacle that we have at the moment. I remember about 3 years ago, Chief Justice Kehar tried to bring in these tablets, and they were going to operate like the Delhi High Court does. Nearly half the judges are using tablets with the briefs in PDF form, and so it's a paperless court. But Justice Kehar, as Chief Justice, brought it into Court 1, and these tablets were kept there, and there was a guy standing next to him trying to help him if there were tech difficulties. In about 5 minutes, they wound it up because they weren't able to get the hang of it, and the tech wasn't working, and thereafter they used those tablets to rest their files on. So we didn't go anywhere with this. So the problem is, I think, training judges or allowing judges of superior courts. They believe that, look, we are beyond learning now. So you can't really train us about stuff like this. Let's stick to what we've been doing all these years. So I think trying to break that mindset and trying to get them to embrace this for the sake of everybody is going to be tough.
Thank you, Gopal. This is super valuable. I mean, in terms of like bringing what actually the ground reality there is for those of us who are not in courts right now, knowing what the process is. But both aspects of continuity and mindsets are equally key. And what we're hearing as a run through this is technologies are available, but it's more cracking the other dimensions. And maybe we'll come to closing that. But Amita and Anuradha, can I quickly ask you to share what you see as an opportunity, adding on to what the panel has shared?
So, so thanks, Supriya. I think, the big comment that we wanted to make was that this is a chance for us to do new things. This is not just us putting in place a situation, a system by which we do old things in new ways, but that we actually get to a point where we can do new things. I often used to wonder in law school what it would have been like to be a citizen of the country when the Constituent Assembly debates were going on. And somewhere this could actually be that point in time for a judicial revolution, where we will be setting how the new process will run. This will not just be, okay, there used to be 50 matters that used to get listed. Some courts had 120 matters being listed. All of them will now be done through a video conferencing facility. That's not how we should be thinking about this problem. We should be fundamentally reimagining what the judicial system is going to look like. We should look at it much more holistically. And the fact that platforms like you, like Agami and Dalberg coming together, allowing for people to come forward and put in place their viewpoints that will actually be collated, be available to the judiciary on what kinds of options are available to them. All of this, I think, will make a big difference. And, I'm completely excited. What a fabulous time to be part of the profession, that we can actually have a say in this. And the fact that it could, technology has essentially said that all of us will have equal access to be able to actually drive some of this conversation. The other thing that I wanted to just sort of pause about, what are the risks that we're looking at, is that we are, of course, looking at this entire situation in the context of a pandemic. And, the urgency to get back to normalcy will drive us to make some decisions that may make sense in the short term, but may not resolve the larger issues and the long-term ability for us to actually drive to a completely new system. So while we are looking at what kinds of changes, we should sort of equally look at short-term and long-term consequences and benefits and, adverse effects while making that through, because that is going to be a big driver. And in this, I mean that, like I said, it's not that we just take, oral hearings and make them video or virtual in that sense, but that we fundamentally reimagine. So we use technology in a way where, case management systems are completely different, that there will actually be predictability. I mean, I can't imagine the number of clients who would drive, cry tears of joy with the idea that there is some predictability as to when their case will come up, for how long will it last, what would be the various implications, the cost runs that happen on clients because of the unpredictability is really weighing our system down. And this is our chance to actually make those changes, to fundamentally reimagine all of that. The last is, of course, that, this is also that point in time where, it's your point about inclusion, that we do get to a point where there is a gap between the haves and the have-nots and how their access to justice functions. And I think many people have written about this. People have lambasted the system for the fact that, if you are of a particular category of cases, you could go from trial to Supreme Court within a year. And there are some where, 65 years later, you're still fighting the same battle. And that is not what, and technology can either exacerbate that or it could actually mitigate it. And we should be very conscious that when we're taking this on as the big game for change, this black swan event and the crisis that we will not waste, we are actually using this to make a big fundamental judicial revolution or transformation in that sense. I'm very keen and hopeful that we will all be mindful that the idea is to bridge that gap. The idea is not that the people who have better access to technology are able to actually increase their access to justice through this process. Anu will sort of run through some of the other points that we have.
Sure.
Hi, thanks, Supriya. Good morning to you all. This is actually a very exciting time, I think, to push in a change of mindset. The stakeholders have been resistant, as Mr. Vaidyanathan said, and Justice Sri Krishna also pointed out that the mindset issue has been the biggest impediment in digitization of the whole process. What we see happening in short term is that urgent hearings are taking place. email petitions are being accepted now. This should have been long coming much earlier. The digitization process till now in India has been very basic, and even in Delhi High Court, it's very basic to the extent that I still have to do a physical filing. I have to go to the court premises to get a scanning done from a particular place, and then the scan CD is filed, and then the protocol, which is available only with the judiciary, the scan filing is with them, and we have a different set of papers, which we again have to go back to the High Court and mark it as per the court protocol. So the process, though is called digitized, though we have orders which are uploaded time to time, sometimes on a day-to-day basis, but the process is very basic and very manual. It is hardly the digitization which it should be actually, and which the world is seeing across the various judiciaries and various jurisdictions. What would, even today in short term, when the lockdown is on, I understand that urgent hearing is only possible because we don't have access to our offices, we don't have access to the files, and so regular hearings cannot take place. But even in the lockdown phase, we see that each High Court has actually taken a different format of hearing the video conferences. Yesterday, Calcutta High Court said that they are going on Microsoft Teams. Delhi High Court is on Zoom. I think Kerala High Court is on Zoom, and Supreme Court, as I just heard, is on Vidvo. So even now, the protocols are not similar, and it's a challenge in the short term which the judiciary is facing. What happens in the medium term, and this social distancing, if it is going to stay with us for say another 6 months, I think it's a good time to enforce and get the documents digitized, the pleadings digitized, the filings digitized in various courts, even at the district court level. I think it is there will be resistance from the bar. There will be physical filings where digitization is not possible, but it is for the courts to give priority to digitized filing at High Court level and all, to get the hearings ongoing once the lockdown is over.
Yeah.
How do I see a digitized judicial platform in the long term, which would actually make access to justice much more viable? We should actually have a judicial platform where I can, from my office, file a petition without having to go to the court premises, where I can go to the notary, or I can e-sign an affidavit and file it. The protocols would remain same, and every time a party files something, each stakeholder who is given the access to that particular link automatically gets a link to the documents, and we always have a common file maintained.
Yeah.
This would not require the lawyers to travel. This will not require the litigants to travel to the lawyer's office and court every time to get an update. It would give the litigant an idea of when to access, which court to access, and will not make the litigant travel all the way to the various courts.
Yeah.
So this digital platform would actually give a greater access to justice and actually not keep a certain type of litigant out of the justice system.
Yeah. No, I think that's an incredibly powerful vision of what the highest potential should be, and couldn't echo more, Amita. Sort of like, this is a great moment in time. And just before I hand it to Justice Lokur, given the issue of mindset has come up so many times, like as potentially like the key point of both resistance and enabler. It's just really interesting to note. I don't know how many of you read Yuval Harari's article, where he speaks about how mindsets also typically shift. If you see historical studies, mindset shift in emergency. When you're in a state of emergency, mindsets tend to shift the quickest. So it's a really valuable thing for us to also keep in mind, to think about what the opportunities might be. States that might be a reality on a normal situation won't be what it is now. But with that, I'd love to hand over to Justice Madan Lokur. Would be really interesting to hear your insights on the opportunity for us.
Can I say one word before Madan comes on board?
Sure.
We were talking of common platform. Look at what is happening. There are several payment systems, but all of them operate on the national payments platform.
Yeah.
Controlled by the Reserve Bank. Reserve Bank is its own uniform protocol.
Yeah.
So all of them are considered secure. Your BIM, your Paytm, and your various other things that go on. everybody, I remember when I started the FSLRC, everybody was saying, oh, we can't have this system in this country. I told them that it was being done in America with, in Africa with M-Pesa. Why can't you do it in India, which is much, much superior as far as digitization is concerned? Now, ultimately, on a common platform, it is being done. So we can have a judicial system controlled by the government, controlled by the national agency, whatever, which is certified to be secure. So all things can be done on the same platform, and a common platform, common protocol can be one. That's exactly what my thinking in the matter. Sorry, Madan, I took away your time.
And just before, one more small announcement to the panelists. There are a few people, in the interest of time, because we're almost at there, there are a few people posting questions at the Q&A tab. If you'd like to type your answers out there, it would be useful in the meantime. But Justice Madan Lokur, over to you.
Yeah, thank you, Supriya. Do I have about maybe 10 minutes?
Yeah, sure, go ahead.
Yeah, okay. You know, I think one of the key points that has come out is the need for a change in the mindset. I think that is absolutely important. Along with that, I would also add that the judiciary has to be proactive. You know, you can have a change of mindset, but then still, you know, say I'm quite relaxed, everything is okay. It can't work like that. I just want to tell you, you know, about the facilities that are already available, because I believe that we have enough resources to do what everybody has talked about right now today. I'll just give you a list of some of them. You know, one is the transparency aspect, where you have the availability of information. I think somebody had mentioned about Sajan had mentioned about the National Judicial Data Grid. You have information available freely to everybody. In addition to that, there are these e-Seva Kendras, which have been set up by the government. There are something like 3 lakh of them. A person who does not have access to a computer can go to the e-Seva Kendra and find out what has happened to his case. So, and the number of people who are asking questions runs into crores and crores of litigants. The second is accountability. You know, the e-courts project has brought in accountability, but the thing is that the judges must take interest to enforce that the information that they get. I can give you a case when 94 adjournments were granted in a space of 3 years. That's roughly about 3 adjournments or 2.5 adjournments every month, only for recording evidence, and the evidence was not recorded. In addition to those 94 adjournments, there were 113 minus 94 is how much? 19 adjournments granted for something else. So 113 adjournments granted without any progress having been made. What has the High Court done to that judge? Have they asked him, why have you granted so many adjournments? Okay. Third, the National Judicial Data Grid gives a lot of information. I think it has brought about a feeling amongst people. Daksh, one of them, for example, Vidhi, another one, for example. They're doing a lot of research on the data that is available. Supriya, you're also aware of some research that is being done. So I think all this, you know, the research that is being done, if it can be put together, perhaps, you know, we can bring about a change that is necessary. Number 4, to a very large extent, petty corruption has been, avoided thanks to computerization. There used to be a time when a litigant would have to pay somebody in the court to find out what is the next date in his case. You know, maybe $10, $20, $100, whatever. I don't know what the rate is. But now, you know, with this lockdown, I'm afraid that, what is an urgent matter, what is an extremely urgent matter, what is not an urgent matter, I think it's going to start a little bit of that petty corruption all over again. So I think the project has eliminated petty corruption to quite a large extent. Number 5 is better management of affairs administratively. For example, witnesses, you know, sureties. You have something called stock sureties. A person is a witness to about 20 crimes. Now, you can find out by just looking at the computer whether this guy is a stock witness or not a stock witness. Or you have a surety. He'll be a surety for 20 criminals. Right? So that better management can be brought about. case management, court management, process management. Anuradha had talked about it. Amita had talked about it. Are we making use of the resources that we have, to bring about this case management? How do you explain 94 adjournments? Why is it that we cannot computerize the processes? Sajan had mentioned about it. Vedyanathan had mentioned about it. Convenience, that is number 7, convenience. Now, video conferencing, yes, there must be a common platform. Yes, there must be a protocol. Yes, the hearings should be standardized, open justice, live streaming, all that should be there, but it's been available since, I don't know since when. I remember when Mr. Dr. Abdul Kalam was the president from 2002 to 2007. One of the family judges in Delhi, granted a divorce by mutual consent where the husband was in the United States. There was a small item in the newspapers. Dr. Abdul Kalam rang up that judge and said, you please come to Rashtrapati Bhavan and tell me how you did it. So I'm talking about pre-2007. That's more than 10 years ago. Have we cashed in on this? We have not. That's where the change in mindset comes in. That's where the change of, the proactive judiciary comes in. Number 8, e-filing. If you go to the e-courts website, one lawyer, Dr. Karnika said, pro bono, she has come out with an e-filing manual, which can tell you how to do e-filing. And that's for the district courts, because at that time you were not concerned with the Supreme Court. Everything is taken care of. All that has to be done is, some slight modifications have to be made here and there. And that e-filing process can be used for the High Courts, it can be used for the Supreme Court. But no, you're reinventing the wheel. Have a look at that manual. She's done excellent work on this, and it gives you all the details. Number 9, e-pay. Justice Sri Krishna mentioned that, yes, there are different ways of making payments, but they've all been standardized in the sense that you can select whichever one you want. There are 4 or 5. It's like a credit card or a debit card. You can take any one that you want and make the payment. It's available. It's available for many things. It's available for payment of fines and penalties. It's available for payment of things like maintenance to the wife, disputed rent, right? Court fees. You name it, it's available. Again, there's a manual on the e-courts website available for that, not being used by anybody. Number 10, e-service, something which we called as N-step. Huge problem. I remember when I was in the Delhi High Court, we had carried out a study. The service was being effected only on 30% of the litigants. And that was towards the last week of the hearing. So if in the last week, supposing on the 1st of January, notice is issued for 1st of March, the process server would go towards the end of February. And if the defendant is there, fine, he would be served. If he's not there, he would come back with a report saying not available. N-step has taken care of all that. You can now, on your mobile phone, you can effect service from any part of the country to any other part of the country. So if you're a litigant in Delhi, you filed a case against somebody in Karnataka, the summons will go by mobile. It will go today. It will be received by the district court in Karnataka today. It can be given to the process server today, and he can go and give it tomorrow, so that you don't have to wait till the last week of February. And if there is some fraud that is being committed by the process server, he's got a smartphone. We said, we'll give you money for the smartphones. Nobody took us on that, took up this offer. The GPS can be recorded. So this process server can't go to somebody else's house and say, when I went there, it was locked. Because then from the GPS, you can find out he didn't go to the right place. Excellent, method of effecting service. That 30%, when we had tried this out in Delhi by just training the process servers, it went up from 30% to 80%. I think if you use this N-step, it can go up to about 95%. Number 11, virtual courts. That was mentioned by somebody. Yes, we did try it out in August 2018. We launched virtual courts in Delhi for traffic offenses. Why did we do it? Because we found that in traffic offenses, almost everybody pleads guilty. You have the option of pleading not guilty, in which case the case will go to the court. You have that option. But the number of people who come to the courts was going into thousands. So through this virtual court process, you can pay the fine if you want to. If you want to plead guilty and pay the fine, you can pay it. You don't have to come to court. So the footfalls are eliminated completely. The idea was to expand this to other petty offenses, local offenses, payment of house tax, delay in payment of house tax, delay in payment of some electricity bill or some such thing. But I find from the e-courts website that apart from Delhi, Haryana, Tamil Nadu, Maharashtra, nobody has used virtual courts. It can be used very, very effectively for petty offenses in the first stage, and then for other compoundable offenses under the IPC and under local statutes, and the second stage. Footfalls will be eliminated completely, and everything is computerized, so you don't even have to keep accounts and so on and so forth. Number 12 is the SMS and email facility that is available to every litigant. All that the litigant has to do is register himself. He gets an SMS saying that this is what has happened in your case. This is the next date. You want to check the order, you can go to the internet. If you don't have internet, you can go to the e-Seva Kendra. You can find out from wherever you want. So there are, a whole lot of resources that are available. Video conferencing is just a very, very minor part of it. And even there, as Sergeant tells us, we flopped, Why are we not making use of all these resources that we have? Once we are able to do that, things like court management, case management, all that will be taken care of. You've got, live streaming, not a problem. It's being done in Canada, it's being done in England, it's being done in Denmark. I think Jamshed mentioned about Denmark. You had 2 weeks ago in England, a trial that was conducted for 3 days by a court of protection. I don't know what it is, but there's something called a court of protection. For 3 days, a trial was conducted on Skype business. Why can't we do it? Right? Now, about time management and so on, which Gopal had mentioned, let me tell you, in the Supreme Court in Fiji, written submissions are given. Mr. Vaidyanathan had also mentioned this. Written submissions are given. The oral arguments are limited, 45 minutes. But because the written submissions are given and we go through those written submissions, there were only 2 cases in which, we permitted the lawyers to go beyond 45 minutes. Otherwise, they would finish in 25, 30, 40 minutes. Maximum, half an hour was the average. The proceedings were recorded, audio recording. When I asked a question to one of the lawyers, the Chief Justice told me, why don't you speak into the mic? So I said, well, he can hear me. He said, no, but whatever you say is being recorded, and only the mic will be able to pick it up for the recording purposes. So if there's an argument that has been made, or if something has been said in the written submissions and in the oral submissions not dealt with, the litigant can say, listen, I want to have a recording of what has been said, and you've not dealt with this point. These are not, fancy ideas. These are things which are working in different places, and we have the capacity to make use of them, but we are not doing that.
Understood.
Right. Okay. This is all that I want to say. Security. Okay. Yeah. I just want to mention one more thing about digitization of records. I think Anuradha had mentioned it, or Amita had mentioned it. Under the 14th Finance Commission, 700 crores was made available for digitizing records. In the E-Committee, we had come out with a free software. We told every High Court was told, we'll just give you the software, you will load it and do the digitization. You want the money, 700 crores is available, do it. Not one High Court took up the offer. And the 14th Finance Commission is now over. That 700 crores has gone back to the government. Yeah, this is all that I want to say.
This is, I think you've highlighted what might underlie the mindset.
2 questions, Madan.
Sure.
Since you have larger experience than I have, I was for a very short time in the Supreme Court. And in those days, it was not a fancy idea to have digitization. A, why is it that the High Courts have not spent the money and were reluctant? And B, so why is it that despite simple things like SMS and WhatsApp service being available, it was not being implemented even in the Supreme Court, forget the High Courts? I can't understand that unless it is only a question of mindset.
Okay, I'll tell you why the.
Sorry, I forgot. There's a third one also. For in international arbitrations, they have been using live note for countless number of years. Now, when I mooted this idea when I was a judge in the Bombay High Court, they said that, oh, it costs about 1,56,000, which is really not hardware, but it requires training of the stenographers. Because there you are right, every observation made by the arbitrator, every question asked by him, every answer given by the witness goes live. And it automatically gets, even you get a printout immediately within a few hours. Why is it that it was not picked up? What is it? You are 14 crores or what you said, 140 crores or whatever that. Why was it not put to good use? I'm really stumped by the idea.
Okay. With regard to your first question, why did the high courts not spend the money? There are 2 or 3 reasons for it. One is that some of the high courts said that, listen, we are very good. It became a sort of an ego thing. We are doing very well. We don't need your assistance. We can do the digitization ourselves. That is number one. Number two, we were talking about digitization of the records in the district courts, right? The district courts, unfortunately, do not figure into the equation where the high courts are concerned. It's either the Supreme Court or it's the High Court. Nobody talks about the district courts. So they were not willing to pick that up, although the software could have been modified and utilized in the High Court. It can be utilized in the Supreme Court as well. But it became a matter of ego and, okay, district courts mein ho raha hai, let it continue. We don't want to waste our time on that. The second question about SMS, in the Supreme Court, we did not do it because, I don't want to say this, but, there were...
I understand you really.
Okay. Now, the third thing about transcription, that typing sort of thing that you're talking about, they use something called phonetics for typing.
Correct, absolutely.
Right? Now, that requires a huge amount of training for that typist.
6 months training is all required, and I'm sure you're a smart stenographer who can pick it up like that.
Yeah, but at the same time, audio recording can be done. What's wrong with that? You don't even need, but yeah, it's a change of, mindset.
So,
We come back to question now, the first point on mindset.
And that clearly seems to be the undercutting thing, because I think almost all of you have established the potential of this, how holistic it can be, the different dimensions. We have spoken about technologies available both inside the system already and maybe that exists outside within the community, country, and the world. But a lot comes both resistance from lawyers within the system and otherwise. Now, the question is, does a moment like now accelerate that shift and push people to behave and respond differently? Our bets would like to I think if we have a chance, this might be the best chance to be able to do that, where resistance would be the least, even if there are going to be people who would still. So given this moment of time, and this is maybe my last, and what I've realized is I've not been best at time management for how much we have talked about courts having to do this. But if we have at least 450 people watching this on YouTube, many of whom are technologists, many of whom are organizations that can help build capacities, many are universities, academicians, and I think a whole bunch of professionals who are out there. And all of us, including ourselves, are interested in seeing what is the role we can play now. If this moment is an unusual one, and one that requires this to be accelerated and fast forwarded, my one question to all panelists, and would request you to be as sharp and short as you can be, on what is it that we can do to help the courts now, to help people who are making the decisions, or us as a community to help make this a reality.
My answer would be shortest: change the mindset.
Okay.
Change the mindset to current times and say, forget what happened earlier, our comfort zone is over. We are in situation like a war-like emergency. In war times, what did we do? I don't know how many of you have seen the wars. I have seen at least the World War, Second World War toward the end, and the Indo-Pak War, and how we were treated, and the Chinese threat of 1961 or 62, whatever that is. Yeah. How did we behave? You can behave like that and say, well, now, for example, right now, the lockdown is affecting all of us, but there are very few people who are not changed their mindset. If you change the mindset, and like in the 1990s, It was the difficulty that we had to sell our gold to the rest of the world, which prompted us to change our whole mindset. And what happened? You change the whole system within it. Liberalization was the result of an emergency, financial emergency. So this, we should take it as a challenge and say, okay, we'll change the whole system now. And for all the Supriyas of the future, you will have a lovely working system.
Lovely. Yes, sir, I see your hand up. I'll come to you next, Sajjan. You'll have to unmute yourself, CSV, sir.
If the lawyers and judges realize that this lockdown is going to continue for 6 months to 1 year, I think mindset will necessarily have to change, because they can't be without a job. They can't be completely shut off in their houses. Therefore, I think this is the best time, and I think it is everybody should be told, look, you are going to face this problem, so be ready for the change and go ahead. Thank you.
CSV, judges get their salary, lawyers will not.
Correct. So the lawyers' mindset at least will change.
Yeah,
judges would not like to remain idle at home. They would like to be active.
Yeah, that resistance from lawyers was pointed out to be a high point. This might help. Sajjan, over to you.
My quick comment is that something of this nature requires multiple thought processes to converge. And unfortunately for us, we don't have multiple justices locus. We have one justice locus who did what he did to the best of his ability. Therefore, if we are taking this process towards an institutional change, judiciary must realize that it cannot do it within itself. It has to engage with technology brains which are outside, organizations such as yours which are outside, and then bring to bear possibly a fruition of this attempt. Otherwise, we will still have small pieces of justice dispensation, technology enabled and digitized, and the vast part of it in possibly the previous century.
Got it. Thank you, Sajjan. Gopal?
Yeah, I wanted to say that while we all agree, and we have seen, Justice Lokur has just very carefully not disclosed more than he thinks is appropriate. But obviously, there is a mindset issue, which is the major obstacle. So I've said this before, and I say it again. I don't think it's the judge's business to handle administration of courts. We need to remove that from judges completely. That's not their expertise. Their expertise is to adjudicate. Let them stick to adjudication. We have so few exceptions, two of whom are on this panel, who are able to embrace more. But the majority of them clearly aren't. So just take it away. Give it to a CEO of each court. That CEO is not going to be beholden like the registrars of today, who are judicial officers are. Give it to a CEO, a complete corporate, a guy with 30 years experience who may be from a Fortune 500 company, who will come there and tell the judges, look, this is what we are going to do. He's not going to ask for permission to do it. Administratively, this is what the system is. Fall in line. That's it. I think we need to have that, because otherwise we're just going to keep on waiting for judges with the right mindset to come in.
Absolutely.
Thank you, Gopal. I'll go to Justice Lokur, and our call might actually drop in a minute or two if we don't close it. So, Mother Lokur, over to you, and I will close.
Just 2 words. I think somebody has to take the leadership, right? There's a lack of leadership. If the Supreme Court cannot take the leadership, let somebody else take it. But we need leadership to bring about this change.
And I think all change comes down to that. And with that, I think I'd like to sort of share with everyone who's listening in. This is really all our moment to step up, irrespective of what conversations may be happening in. If you're interested in being a part of this conversation and seeing how we can make this a reality, please do write into me or to our team ID, team@agami.in, and we would love to understand what exists out there, what roles each of you are willing to play, and see how we can build literally a team of teams working towards this. We will also be continuing our series on other opportunities that might be opening up for the legal system. Sometime next week, we'll come up with a date and time. Will be on online dispute resolution and seeing the opportunity for that in this moment and the years to come. So follow us on Agami, the Agami Twitter handle and Instagram to stay tuned on future conversations and progress on this work. Thank you.
Yeah, thank you.
Thank you to everybody.
Thank you very much.
Thank you very much.
Subscribe to our YouTube channel and click the bell icon.